Hello and welcome to Class Solutions Dental Education Podcast, the podcast series where we share knowledge and experience to provide value to you and to your dental practice. I'm your host, Phil Cole, and I'm with my co-host, Chris Webb. And in today's episode, we're going to be talking about dental contracts or agreements and what you need to know and learn about what needs to be in or should be in those agreements to protect you and really in general in both parties. And so today I'm joined by Joe Hess of Joe Hess Law, who will be sharing his expertise and experience when it comes to those agreements. So welcome, Joe, to the Dental Education Podcast.
Thank you, Phil and Chris, for having me on.
Yeah, absolutely. So, okay, hot topic always. You never can get a lawyer on in an interview or anything without having all kinds of questions. We're going to tone it down to just a couple, but the important ones
Sure.
for us, especially since it's a new year, 2023. We have all the D4 students that are going to be getting close to graduation. First, they worry about getting that they graduate and that they get their boards. But after that, the next, of course, big thing is associate contracts. Can you find us an associateship? Where do I go? What kind of associate? Should I go work for the big DSOs, the Heartlands, the Aspens and stuff? Some want to go to community services and stuff. With that being said, all of these are gigantic monsters in some way or the other, and in what they do. So with associate contracts, obviously important, but what would you say are key factors that these graduates coming out, or in that matter, anybody that's an associate now that wants to move to another associate place, what's some of the things that they should be looking for and what they should have in there to be considered a good associate agreement?
Sure. Yeah, great question. And it's good timing too, because I've been getting a lot of requests from dental students who are going through that phase right now. For those students that are graduating this coming spring, they're already reaching out. And like I said, I'm feeling a ton of requests, which is good, because my first point I wanted to make was that you always want to have an attorney review the contract, right? And even better, somebody who has dental experience. I can't tell you how often that dental students are afraid to spend some money, and it'll come back and bite them in the butt later on, because I get calls all the time from students, well, former students, but they're dentists that have been out of school for a couple of years, and they have some issues with their contract that they want to resolve or have me to resolve. But if you've signed it and it's generally reasonable, your hands are often tied. So, whether it's somebody like myself, there are other dental specific attorneys in Michigan and across the country. It's just a good idea to have somebody review it. And, shameless plug for myself, I'll do it at a fair rate. It's not going to be an astronomical price. So don't, as a student, don't worry about that. I'll work with you. And then moving into the actual contract itself, there are a few things that I'm going to bring up today. And each of these could be a whole podcast in and of itself.
Right.
As a starting point, make sure you're understanding your salary package or your compensation package, right? It seems obvious, but make sure you understand it. Are you going to be getting a flat fee? Are you paid on some sort of formula or combination of both? Right? So make sure that's spelled out ahead of time. And oftentimes the dentist, the student, and the practice owner will negotiate that ahead of time. But just have an idea of what you want, and pay attention to, if you're paid on a formula, pay attention to how that formula is defined. Are you getting paid on production? Are you getting paid on collections? And what does that mean? Right? What are they taking out of your bucket that could count towards your collections? Right? So just pay attention to that. And then, lab fees, how are those being handled? Because there's always going to be some sort of situation where the lab fees are at play, and those are going to be taken out. Or as a associate, are you going to be responsible for paying for 100% of those or a reduced percentage of those?
I'm going to interrupt you real quick, Joe, because I do have a question for you on that. Just because of with technology now,
Yeah.
3D printers, the mills and stuff like that. Are you finding that the associate, that the lab bill, at least I would say on our end, we're starting to see a very, very, it's becoming more common, the decrease in a lab bill because of the fact that there's so much in-house stuff being done now versus the old traditional 10 years ago, you send everything out to a lab.
Yeah, I think that's true. I mean, I think I'm seeing practices not even address it in the associate agreement when they're preparing it, which leads me to believe, like you said, it's not as big of an issue anymore with technology. So that's a good point. The last point I want to make on the salary component is, and this is for the students out there, so the new grads, as a student, there's going to be a ramp up period when you join a practice. So I always recommend that you try to negotiate some sort of daily minimum that you're receiving for a period of time, whether it's 3 months, 6 months, whatever it is. So it'll look something like this, daily minimum, you're entitled to 600, and I'm just throwing numbers out there, but you're entitled to $600 per day or 33% of net collections, whichever is higher. So that way you're at least guaranteed some sort of daily minimum when you're joining the practice and getting your feet wet for the first time. So always try to negotiate that from a new associate perspective. I think that's incredibly important. And then the other component, in addition to your salary, your compensation, but related, is the benefits package. What sort of benefits are they offering? Is a practice owner going to pay for your malpractice? Are they going to give you CE reimbursement or credit or a budget for CE? Are they going to give you 401k money? Are they sponsoring some sort of retirement plan? You want to have all of those things specified in the contract, because the more specificity that you have, the less likely there's going to be dispute down the road. So just to recap, make sure you fully understand your total comp package, not what you're just getting, not just what you're getting paid, but also what sort of benefits are they offering for you. I think that's topic number one in terms of associate contract. I got a couple more. Phil, you have a question?
Well, no, I was just going to say that there is one thing about that CE, because it gets brought up all the time. Who's going to pay for the CE? And I just think it's important for the dentist that wants that associate to actually offer that. I get doctors all the time that will say, well, why should I have to pay for their CE? They're just an associate. They should educate themselves, because what happens if they go somewhere else down the road? You can go ahead, and this is my opinion only, you can go ahead with that attitude of that, but you also have to understand that if you are going to have a team environment and a healthy environment in that practice, then educating, getting that associate, and if you want an associate around for a long time, getting that associate to feel as though it's an absolute part of the team and it's not a separate function that is just used until I don't need you anymore, per se, kind of attitude. That is so huge. And to have them educated and getting constant CE so that they can better that practice while they're there. We see it all the time when doctors make that associate part of the team and part of the practice. Associateships can last a long time. It's the guys that don't, that treat it as though this is a part-time situation per se, that you see them just rattle through associate after associate after associate. And we know, because we're the ones, Chris and I are getting these calls all the time. Find me an associate, find me an associate. How many have you had? Well, in the last 5 years, I've gone through 3, 6, whatever, and it's always the same thing. It ties into the benefits package and these things that you're going to continue to bring up on this question. But it's just, I think it's important for everybody to understand those things, that not the person that's not the associate that we're talking to right now, but the doctor themselves, the owner, and what they need to be concerned about going in that contract as well. So I apologize for cutting you off, but go ahead.
With that, like, so I've seen for like CE, right? I've seen a few different ways that's allocated, whether there's a specific allowance, whether it's like, hey, CE that you want to do is totally like on you as the associate, but anything that we do as a practice or that we want to make mandatory, then we cover. And then I've also seen where it's like, hey, I'll either pay for your CE or I'll pay for you to be a member in this particular study club, and I'll pay for your study club dues, and you can join us and be part of that and be part of that regular doctor to doctor, study club. So I guess to kind of follow up with it, Joe, you've seen more than what I have. So have you seen other different creative ways that they've offered to do CE?
Those are, I mean, the ways you talked about is generally what I see. So, I mean, to echo off what Phil said and to in a roundabout way answer your question, I think it's important that, like Phil said, that the practice does offer some sort of CE, because Phil, you hit the nail on the head. I mean, it's just going to better the practice, right? And if you're the owner, why wouldn't you want to better your practice? And it's not only in dental industry, but any industry right now, it's hard to retain talent, right? Find good talent. So, and it's particularly true in the dental industry. You want to be able to attract talent and keep them. And, what better way to do that than to say, yeah, I'm going to give you a nice budget for CE. Of course, I'm going to pay for your malpractice insurance. Of course, I'm going to pay for your licensing fees, right? And a quick point I want to bring about that too right now, about the team environment and not looking at this as just like a transaction. I get frustrated when I see contracts that, okay, yeah, we're going to offer you some sort of CE credit or budget, but if you leave within the first 2 years, you're going to have to pay it back to me. It's like, I don't know. It's just, I understand it. As a practice owner, you don't want to lose that money. You don't want to pay for somebody who's just going to leave, and you don't want your practice to be a revolving door. But, I think you're setting yourself up somewhat for failure by anticipating, well, this person's probably going to leave, so I want to make sure that he's going to pay, or he or she's going to pay me back if they leave within the first 2 years.
It's the mindset, right?
The mindset.
You just got the wrong mindset to go in with that mindset. It's a fail mindset versus having a successful mindset. And I'm going to give these guys what they need, or gals what they need, to be able to get what, to make make them productive. Because ultimately, like said and done, you're talking about doing, $1 a day minimums and stuff until they get up to speed. Well, what's one of the best ways that they get up to speed is also being educated. So, I mean, it's kind of that also rolls around, through the whole process. So anyway,
one of the best calls I've got recently was from a practice owner who was going through the struggles of trying to find an associate. And they found a good associate, and we spent at least 30 minutes on the phone going through all the possible benefits and packages that they could offer. And they were sincere in it. They kept saying to me, or she kept saying to me, I want to make sure that this person feels welcome, and I want to offer the best package I can to that person. And I don't hear that very often. And I thought that was a great start to a relationship. Whether that turns into a partnership, whether that associate buys that person out, you're starting the relationship on the right foot that way.
No, I agree 100%. And I think one of the last thing that I will piggyback on that is when she put a lot of effort, it sounds like to me, into really considering the practice, what she can afford, what she can't afford, and so forth. And I was just going to say, I think the biggest thing that when you're bringing on that associate is, once again, do you know your numbers? Do you know what your break-even point is? Because for you to say, I can't afford malpractice, I can't afford to do the things, blah, 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 which we hear a lot of times, I can't afford it, or, did you do the break-even point? Because when you do your break-even point and you find out that you could give them $1,000 a day, full benefits, malpractice, insurance, and all this stuff, and still be making money and being profitable off it, it's a moot point. So you shouldn't even have brought it up, and you shouldn't even started that conversation. So, okay,
good point. Sorry, like I said, we could talk all day about each one of these topics. I'll try to. There's two more that I just want to touch on for associate contracts. One is the termination section. Very important to look at. You want to understand. I mean, some of this stuff seems really obvious, but you want to study it. You want to make sure it's specific. You want to understand how long is your contract lasting, right? Because Michigan, like most states, are at-will states, at-will employment states. So you can be fired, terminated for any time for any non-discriminatory reason. But if there's a term in the contract, And if there's notice periods required for termination, I mean, that somewhat modifies that at will status. So you want to make sure you understand that both from the practice and the associate's perspective. And in particular, where I see associates get themselves into trouble, again, by not hiring somebody to look at their contract or just accepting whatever's thrown at them, is penalties for not providing enough notice, right? There may be a provision in an associate contract that says the associate can terminate at any time without cause, so long as that associate provides 90-day notice, right? And if that 90 days is not provided, sometimes there's a per diem per day amount in the contract that the associate has to pay the practice if that notice period is not withheld. And I get calls all the time. Is that enforceable? Well, yeah, it is enforceable. Did you sign it? Yes, you signed it. Did you have anyone look at it? No, I just signed it. So just be on the lookout for any sort of tricky things like that. The last thing, a very important thing in associate contracts, restrictive covenant.
Yep.
Make sure you're looking at that, right? As a practice owner, I have the benefit of being on both sides of the aisle for these things, right? I represent a lot of practices, so I do the drafting of contracts, and I represent a lot of associates who are negotiating their first contracts. As a practice owner, the practice owner wants to push the envelope as much as they can for the non-competes, right? I mean, and that makes sense. On the flip side of that, the associate wants the minimum restriction possible. So there's that tug and pull that's always at play there. And again, we could talk about this all day. I'll say the biggest issue that I see associates getting themselves into are situations where they sign associate agreement with a non-compete in there, and then I provide advice and say, hey, the radius on this is probably a little bit too long. It's going to restrict you from working in XYZ cities down the road. Oh, don't worry about it. I'm never going to want to work there down the road. If I want to start a practice or buy my own practice, I have no interest in looking around this city. And then I get a call 2 years later saying, hey, Joe, remember me? Yeah, of course. So I found a practice. Oh, great. Where's it at? Well, it's within my non-compete zone. Is it enforceable? Can I buy the practice, right? And I say, well, remember that conversation we had? The point of me making that is to not only be comfortable with what you're signing now, but think about the future. You're never going to know what the future is going to hold for you as an associate, and you want to get that radius down as low as possible from the associate's perspective.
Yeah, no, I agree 100%.
And to look at it and remember, the radius is as the crow flies.
Yeah.
So it's not like you can go to like mapquest.com and figure out, hey, am I out of this radius? Because twists and turns don't count, right? And so that's where, when you let it extend, I know I've been in conversations with doctors looking to buy a practice or start a practice. Like, hey, I found this great location. Awesome. Let's look at your non-compete. Oh, your non-compete is 15 miles and this one is like 14.5. Well, that half a mile doesn't matter, does it?
Yeah,
no, it matters.
That's another good point, right? Because we get that, we've got that question a lot, and I've got that question a lot, and it's like, my response is, yes, it's reasonable. The mileage radius is reasonable, and if everyone started saying, well, is this really enforceable? Because I'm technically only 0.5 miles within the non-compete, so it's probably not enforceable. And I'd say, well, then what's the point of having a 15-mile non-compete? It should have been 14.5. So whatever numbers in your agreement, assuming it's not, out of the ballpark, it's going to be enforceable in Michigan. And most states have, or most states enforce non-competes. Now, there are other states like Colorado and California that are different. And of course, right now there's some legislation out there about banning non-competes federally. What impact that'll have, we don't really know. But as of right now, in the state of Michigan and most states, non-competes are enforceable so long as they're reasonable.
Well, and I think the other thing too, that and I know that it's growing, the knowledge is growing more on it, but I just ran across a buyer 2 weeks ago when we were talking, looking down in Florida, and they want to buy a practice, but they're with a large group practice, not a DSO, but doesn't matter, large group practice that has 8 locations.
Yeah.
The first thing I asked is that non-compete, is your restrictive covenant on your practice or on all 8 practices? No, it's on just my practice. Would just do me a favor, send me it anyway, right?
Yeah.
As soon as I get it, it's very vague wording, but I can tell if I sent it to you, you would be like, nope, it's all 8.
Yep.
And so now you just, where they want to live, that non-compete doesn't, is just over the restrictive covenant where they want to go, they're just over it. They're safe on that one. But boy, you go over to this other one and guess what? It's within a mile and a half outside of it. And I guarantee you that guy put that in that contract, the owner of that large group put that in that contract for that specific reason. And guess what? Now what do you do? So
yeah. No, that's a great point. I run across that issue a lot as well. And again, I mean, not to beat a broken record here, but it comes down to associates signing agreements without having legal representation, right? If I'm looking at that, there's no way that's going to fly, and there's no way that I'm going to let an associate agree to that. Now, if that associate of those 8 practices is performing, 40% duties here, 60% duties here, well then, yeah, I guess there's an argument that can be made that he or she, the non-compete will apply to him or her based on working at both locations. But if that associate is truly only working at one location, never been to the other 7, doesn't have any interaction with the patients there, that's unfortunate. And in that scenario, right, what do? Do you roll the dice? I mean, you got to take some sort of legal action. Probably somebody's going to take a legal action. Either the practice is going to sue you, or you're going to have to go to court to get a judge to say this is unreasonable and scale it back. So you're kind of caught between a rock and a hard place in that scenario.
Well, we ran across it in Wisconsin. It was a mile, less than a mile. I think it was 4/10 actually. Oh, we get along so well. We get along, blah, blah, blah. The typical, once again, I mean, it's kind of like you said, beating a dead horse here with how many times we hear it. But, he would never do that. Boom. The owner found out that he was looking at that practice, found out through the grapevine. I don't know how he did, but I guess the first thing he said is you move, I'm slapping the one on you right away. And it's just like, all of a sudden it's like, boom. He's like, I can't buy it. I'm like, well, we tried to tell you that from day one that you're spending too much time on this. And boom, it was like, but convinced that the seller or the owner was so nice and that they would have no problems with it. Well, when it comes to taking away patients and stuff, it becomes no longer, friendship. It becomes a business. Right. And that business has got to protect itself. So.
No, yeah. I agree. Worst thing you can do is just rely on the good relationship.
So talking about like protection, if we kind of switch gears into like an acquisition or an asset purchase agreement, what are some of the things that are super important to have if we're going to call it a fair contract?
Sure. Yeah. No. Another good question, and again, another topic we could spend a lot of time on. So kind of stepping back, I look at these deals in the following way. There doesn't have to be a winner and a loser from the buyer and seller side. A lot of attorneys would probably disagree with me. A lot of attorneys act in disagreements with me. But, when in this specific industry, in the dental industry, when a buyer and seller come together, they want to get the deal done, right? It's not my responsibility to muck up the deal. Now, I can still adequately protect either side that I'm on, but it doesn't need to be a situation where I'm trying to win and make the other side lose, right? And I think you guys can attest to that based on the contracts that I put out. So I think that's the general starting point that I walk into in any deal, no matter if I'm on the buy or sell side. Doesn't matter, right? You can present a fair contract no matter which side of the table that you're on. Now, to your specific question on things that are going to be in a contract to make it fair, since we are dealing with a dental specific transaction, you can't just pull an APA off the internet. or just use a general attorney who doesn't necessarily know what they're doing, doesn't have that skill set. So, I mean, there are a few things that I just want to quickly highlight to make sure that they're covered in a dental specific APA transaction. So first one is accounts receivable. Make sure that's spelled out specifically, right? You want to ensure, and there's usually one or two ways to handle it. Either the ARs are being bought or they're being collected. Again, generally that's how it's done. So you want to make sure that you have the specific standards out there for what the purchase price will be if the ARs are being bought. You want to, if they're being collected, you want to have a specific timetable for how they're going to be collected and for how long, and paying the administrative fee, and etc. So again, make sure you're very clear on those provisions so there's no disagreement down the road. Another issue that again comes up in dental transactions, your APA needs to address redos and retreatments. So for example, if the sale goes through and there's a post-closing issue that comes up, but it relates to pre-closing services provided by the seller, right? Does your APA address that scenario? Because it should and it needs to. And again, there's standards on how that's handled in terms of how long that retreatment period is and who's going to do the retreatment and who's paying for it. Again, get yourself a good dental attorney so that you can ensure that provision's in your contract. So you don't want the buyer and seller to be fighting post-closing over something like this. You want to make sure that that's in the contract itself. Third point, representations and warranties. Again, reps and warranties are going to be in any APA, no matter if you're doing dental, manufacturing, restaurant, no matter what it is. But again, because we are in the dental industry, you want to make sure that you have specific reps and warranties applicable to the dental field. So again, you just don't want to pull something off the internet or use some general form, because you're going to have likely have a ton of irrelevant reps and warranties, and you're going to be missing some important reps and warranties as well. Last point that I'll make on this topic is the transfer of records. I've had this issue come up a few times lately. That's why I want to raise it, and it, maybe not be such a hot topic, but it's come up a few times, and it's this. Because we're dealing with a dental sale, you want to make sure that the contract itself says that we're not paying for the dental records, right? They're being transferred over because it's illegal to pay for them. But you want to also pay careful attention to what records from the buyer's perspective, what records are you taking custody of? Is it defined as active? Is it defined as all? Are inactive records excluded, patients excluded? So a quick example on how this came up recently in a deal where the seller had records from 15 or 20 years ago. And in Michigan, the retention time period for maintaining these records is only 10 years. So after 10 years from the last treatment, after 10 years, you can shred them, get rid of them, right? The seller kept tons and tons of records in a storage unit and was basically like, all right, buyer, you're buying my practice. Here are all the records too, and you got to figure out where you're going to store all this stuff. I was like, no. We're not taking all this stuff. So again, if you sign an APA and you're not paying attention to that, and it just says all records as a buyer, well, you're probably going to inherit all records, and there could be some old ones that you're going to have to figure out where you're going to store them, or you're going to be responsible for getting rid of them when the seller really should have done that before the deal closed.
Excuse me. That I got choked up on that because it's funny because you remember we worked with a client, and that's exactly it was funny because he went out to a shed. This was not disclosed, even though we told him to ask. He didn't, but the seller didn't disclose. And the next thing you know, it was probably about 6-7 months later, there was a question asked, and it's like, oh, you might want to go check the shed. Go out to this metal shed, and there's nothing besides boxes and boxes of 30-year-old client things and stuff. And so ended up spending tons of money bringing in the old shredding company to sit there and just go shredding all the files because he wanted nothing to do with these things, but it's funny because it like you said, it is happening a lot. I mean, that topic is becoming very popular.
It's becoming more relevant now than even a couple of years ago. And that's why I brought it up. It doesn't seem like something that we would be discussing, you know, what's important in an asset purchase agreement, right? Purchase price and restrictive covenants. Of course, all that stuff's important, but I just tried to bring up something that's been coming up more regularly than it has in the past. So you just want to pay attention to that.
Well, I think the other one that I think is becoming relevant, and I'll bring this one up too. And I don't know, you and I have not discussed this, Joe, so I'm not putting you on the spot, but maybe you can at least give your quick opinion. I've always watched doing a transition, the credits, but I'm noticing more and more that the amount of deals that have gone through different people, since we coach and stuff too, that when we're coaching and we're seeing a tremendous amount of credits, those credits can't be transferred over. Like that's against the law. They have to either be if you either have to remit those back to the patient, or they have to sign off that they're willing to carry that credit, into the new purchase and stuff.
Yeah.
How are you running across that as well, or is that something that?
No, that's another good point. Credits come up in 100% of deals.
Almost every time now. It's like impossible not to now.
There's, anything from, hopefully a $1,500, dollar balance, and then up to $80,000, $90,000, six figures in credits, which is just, outrageous. But yeah, again, if you don't know what you're doing and you don't hire the right attorney, this stuff is going to get overlooked. And there is a standard, there is a way to handle it. And you brought up a good point. I mean, they're not just going to magically transfer over. There's got to be some sort of contractual language. And if the seller's has a huge credit balance on its books, look, starting point, figure out what that is when you first start the transaction, right? Even if you're 60 days away from closing, get an idea of what that is at the beginning.
Yeah, it's got to be due diligence.
Correct. That's due diligence 101. That's part of what you're looking for. And then, as you're getting further along the deal, the seller should be crediting that money back to the patients as you're making your way through the deal. That's the ideal scenario. Does it always happen? Absolutely not. But as a buyer, once we get the balance, okay, it's $50,000. All right, seller, we're not closing for a month or two here. You need to start getting that money back to your patients. And assuming, again, 99% of the deals you get to closing and there's still a patient credit balance, where your asset purchase agreement needs to address that, right? If we as a buyer agree to assume some of those credits, then we better be getting a credit off the purchase price or get some sort of check being made out to us at closing, right? Because if not, well, then you're potentially inheriting credits on the books, and now you got to provide free services. You're not getting compensated for it. So big topic. Good point in bringing that up. And there's also these things called state achievement laws, which basically you have to turn over unclaimed property to the state after a certain period of time. In Michigan, I believe it's 3 years for patient credits. They fall within that bucket. So from my perspective, if I'm representing a buyer, I don't even want to inherit or take over those credits that are 3 years and older, or older than 3 years, because if I can't get those back to the patient, then I technically under law have to turn them over to the state, and what a pain in the butt to deal with. So when I'm on the buy side, I'm putting in the contracts, we'll take over the credits, but they got to be less than 3 years old, and the seller's responsible for doing anything older than that.
Yeah, and I think that, like you said, having a dental attorney to do this, but I think that once again, this is, I guess maybe a shameless plug for us, but you've helped us with this too, sitting down and creating. So we create that an APA. We have a worksheet with that APA that we worked through, especially since all these things that we're discussing today. We sit down with our buyers and sellers together and go through this lengthy worksheet so that we make sure every one of these things is covered. Yep. So that if they're not going to use you, or they're not going to use a dental specific lawyer, at least we know at Class Solutions, when we can hand that lawyer this worksheet and say, don't muck it up.
Yeah,
because like this has been agreed by both parties. on
Yep.
what is going in, AR allocations, you know, credits, all that stuff, and all the other restrictive covenants, all that's built in. Now don't muck it up. And the reason why we went to you and you helped us build this worksheet is because we didn't want it's those lawyers, because you take it there and the next thing you know, the deal is going awry because of a situation where they don't know what they're talking about. And we're fighting. And a lot of times you've been on deals for us, Joe, where we're dealing with a lawyer that you're actually teaching them
Yeah.
what needs to be in these contracts. And we've had one that should have closed within, 3-4 days with the APA getting filled out and the closing date. And we had to push closing date back. What I think that one in 2 summers ago was like 2 months, because we could not get the lawyer to understand, what credits were and everything like that. So I think it's just gigantic to make sure that, and I think there's, once again, is I always distinguish myself as we are a transition consulting team. So we're consulting all these things throughout the whole process, bringing you the specific team members that need to be brought in, dental specific, to handle these transitions versus a broker. I feel and that when you deal with the broker, I brought you the practice. Now go, you should do this stuff, or you should know how to do this stuff. I look at it as, even guys that have bought 2-3 practices still make mistakes. Make sure you're going through everything big time. So,
yeah. I mean, this is like one of the most important decisions you can make in your life, right? Buying or selling. You want to make sure you hire the right team. You don't want to just hire a family member or generalist.
Especially when the majority of them are only going to do it one time in their life. So, you don't have room for mistakes.
Right.
All right. So the
one
last
time on each
one,
end.
Oh, I'm sorry, Chris.
I was just gonna say just one time on each end of their career, right?
Yep.
And why pay for it with either a bad contract or a bad deal, and it's literally to try to save money, but you don't end up saving money, because think of all the hours you're paying that attorney to learn how to do it, and they're still not going to do it right, which is what I've seen time and time again when I'm working with Joe on stuff and the other attorney is bringing things and I'm like, Joe, what are they doing? Like, I don't even have a grasp on law like you do, but this doesn't make sense. And so you're just watching them rack up bills for attorney fees to learn what they're doing.
Yeah.
It doesn't make sense.
And major attorney fees.
Not efficient. It's not efficient. I mean, just quickly on that point, I mean, I generally try to work off a flat fee in most projects, as you guys know. Once I understand the scope, what the practice sale entails, what's going on with the real estate, if there's going to be purchase or lease, if there's going to be an associate contract after the fact. And then, I'll give a flat fee, or at least from the beginning, I give a pretty tight estimate on, it's going to be between X and Z, and it frankly always comes between there unless something crazy happens. But that's the benefit of having somebody on your team who understands this stuff and who lives and breathes in this every single day, not somebody who touches a dental deal once or twice a year. That's the big difference.
Yeah. I agree 100%. Okay, so last but not least, something that seems to me is starting to be talked about again. I think it went away there for a while. It's becoming popular again. Excuse me. Partnerships. Me personally, not a fan of them. Just because of the simple fact that there's a lot that goes into it. And like I always try to say is, you're basically marrying somebody. Yep. And so are you ready for this relationship? So what are some of the musts for both parties to give for a win-win partnership?
All right. I'll try not to speak too long into this stuff because I know I've been rambling on. A few things. I mean, let me back up. You hit it again. Perfect. It is another marriage. So that's literally one of the first things I tell people is when they're getting into these situations. They can work if they're done right, if they're documented right, but they may not, right? But it's a marriage. You're marrying that person. I think a few things, or maybe 3 things to think about when you're doing a partnership and have these discussions up front and of course make sure everything's documented. But I think the best partnerships are ones that are 50-50 rather than 20-80 or my favorite, the 49-51% partnership, right? Well, I want to this the owner, I want to bring somebody in as my equal partner. Well, how much do you want to give them? 49%. All right. Are they going to be a manager too? No, they're not going to be a manager either. So it's like, okay. Again, everyone has their own agenda and stuff like that. But from my perspective, looking at it from the outside and just seeing enough of these, I think the best partnerships are the ones that start at least 50-50, right? If you got an older doc who's eventually going to be bought out, I understand the percentages may change down the road. But from a practice owner's perspective, if you're thinking about having somebody buy into the practice, I would recommend starting with that 50%. I think you're going to start off on the right foot. I understand you're maybe giving up more than you want. You think you may be giving up control, but you are. I mean, that's the point of a partnership, right? Right. And so I think, to just echo that point, I think it needs to be a 50-50 partnership, right? And within that 50-50 partnership, both of you should be making managerial decisions, right? Now, of course, people may disagree with me, and the partners may disagree and think, well, what happens, if we each get a say in something 50-50? Well, how do we decide something that we run into a deadlock on? Well, that's the point of having a good dental attorney. They'll draft your shareholder agreement or your operating agreement or bylaws, which will talk about situations where you do become deadlocked. There are outs for that. There are third parties who can handle it. There are buyout provisions. So I just think 50-50, make it that way. Make sure each of you got managerial rights and run the practice accordingly. Second thing, compensation profits. Make sure you guys are understanding, make sure the partners are understanding how you guys are going to be paid. You want to do that at the beginning. I'm going through one right now where the partners are disagreeing over the compensation and profits formula. They should have, from my perspective, and the attorneys are arguing over it, right? But it's like, I don't have a bone in the game. I can tell you what I see generally, and I can tell you what I recommend, and I can argue with the other attorney all day long, but really it's the partners that should have sat down before they got the attorneys involved and say, all right, yes, we're going to be 50-50 partners. Yes, we're going to, our compensation structure and our profit structure is going to be this, X, Y, Z, right? Get that hashed out ahead of time, because I'm dealing with a non-dental specific attorney on the other side of this one, and it's becoming problematic. So hash that out ahead of time. The last thing that I want to touch on with partnerships and things to think about, you should think about beforehand. What happens if somebody dies, or what happens if somebody becomes disabled? What if your partner's embezzling money? What if your partner retires or wants to leave the practice? There's got to be agreed upon buyout provisions, mandatory, in my opinion, mandatory buyout provisions for those scenarios. The last thing you want is a situation where your contract wasn't done right, or it's inadequate, and you have a disagreement, or somebody, God forbid, passes away, or somebody wants to leave the practice, and you don't know what to do because your contract doesn't address it, and you feel stuck. Phil, we've had one of those scenarios. Yes. Not that long, maybe about a year or so ago. But again, you want to make sure you're on the same page for those important, I call them triggering events, in the event that something happens to one of the partners.
Yeah, no, I agree 100%. I can't. I think that once again, this is one of those situations where a lot of it is negated if you have these conversations before you go to contract.
Yeah, 100%. You should. You definitely should, because you'll vet out these issues early, and there's a less likelihood that I'm going to have to be sitting there arguing with the other side, the other attorney, about stuff that really it should be up to the partners. You just got to have that communication ahead of time.
Yeah, and I think the other one is once again the 50-50 thing. I just been doing a evaluation out in Colorado Springs, and it wants to do the partnership, and it's the first thing after we get to evaluation. And I said, okay, so how do you want to set this up? And the first thing he says is 51-49, and it was just immediately like, the whole time you're talking, he's like, my associate is, just really, really good. I just really like him there. He does a great job. He fits in, blah, 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 blah. And the first thing is, so why 49?
Yeah.
Well, I want to make sure though that I'm going to be around for 5 more years. I still want to make sure that I'm the one that's making the decisions. I'm like,
Yeah.
I get that.
Yeah.
But then that automatically, now you immediately, if you have a relationship that you have, like you say you have, you just caused animosity immediately, because that guy is going to sit there and immediately say, well, wait a minute, why 49? And as I told him, any good lawyer, dental lawyer, is going to look and say, why would you do this deal?
Yeah.
Right?
Yep. I agree. You're, again, back to what we talked about earlier, you're starting the relationship off. In my mind, there may be situations where it's applicable, but I'd say 9 times out of 10, if you really want a partner, then that partner needs to have equal say. That's what it comes down to.
And for us, our transitions, we believe in simple, fair, transparent transitions. And the simple comes first in our motto, because it can be very simple if there's 2 things. You are fair. And once again, getting a dental attorney like yourself, and we have other dental attorneys that we work with, in Georgia, Utah, and all over, that have the same mindset as you, the same concept as you, and that's the reason why we work with them, because once again, that it's when you can have everybody understand that you can have a win-win.
Mm-hmm.
I mean, you see so many of these other brokers out there that push there's no such thing as win-win. It's absolutely false. There is 100% of the ability to have win-win, because that's what both the buyer and the seller want. Originally, they all come with that same pretext: is I just want to win. I just want it to be fair. It's everybody else that mucks it up, that causes them to lose that mentality. But fair, and then like I said, the transparency, and that's once again, if we work with them from the very beginning, the inception to the close, and we're bringing in our dental professionals, this thing can be so transparent and so simple. You just need to make sure you're working with someone that covers all the bases.
Yep.
And I'll throw one more plug in for you, Joe. There's the old sales adage of you got a good deal when everybody walks away equally pissed, which is stupid, because realistically, if you've done it right, because your dream as a buyer and your dream as a seller is you're taking this business that you've built, this practice you've built, and put your whole life's work into, and you're going to hand it off to somebody that's going to run with it and carry your legacy on. And basically, you're just going to hand the torch off, and they're going to take off running. And for any buyer, they're kind of feeling the same way, like, hey, I'm taking on this person's like business that they built, and I'm going to go run with it. They want to get to the end and feel positive about it, not feel screwed. Mm-hmm. So that equally pissed is just stupid. But I've done so many deals with you where we get to the end, and because everybody's been open and transparent, we get to the end and everybody's smiling and happy at the signing table, and everybody walks away feeling like, man, this was really good. I feel really good about this.
Yep.
And I think that should be the goal we aspire to, not to be equally pissed, but to be equally excited and happy for one another.
Yep. There's nothing more uncomfortable than walking to a closing where everyone's been fighting.
Yeah. Yeah.
When you look at me, Joe, at a closing, and when we're walking in, and you're like, so is this going to turn out?
Right. Yeah. Right. I know. So you just surround yourself with the right team, like yourself. You guys handle the transition flawlessly. Get yourself a good dental attorney, and it'll be a good process. It can be. It doesn't need to be. It doesn't need to be litigious or contentious or anything like that.
Yeah, no, totally agree. It's 100% preventable. So if anybody that is listening wants to check in with you, it's joehesslaw.com, correct?
Yep, joehesslaw.com, and my email's an iteration of that. So joe@joehesslaw.com is my email address. So you can just go to my website. You can look a little bit about what we all do, and we handle anything from acquisitions to associate contracts to real estate and everything in between. And you're
not just Michigan, right?
No, not. Yep. So I
Yes.
work. Yeah, I work. I've done work in probably 30 states across the country. Um, Heavy emphasis in the Midwest, but we get down to Florida sometimes and out west. But yeah, I'm all over the place.
Okay, I just want to make sure everybody
Yep.
realize that, and that those who are listening don't feel as though they just have you in Michigan, so
Nope. Nope.
they can
Yep.
reach out to you anywhere and use you.
Correct. Correct.
Well, I appreciate it. Thanks to you, Joe, for checking in with us and giving us some good information. We are definitely going to have you back because, like you said, one of those questions we could have spent the whole podcast on. So we'll
Yeah.
dive into some other things later. I know we're going to put some things together too in a webinar down the road in the future here too. So really appreciate it. Once again, anybody that wants to talk to Joe and learn more about his services stuff, joehesslaw.com. And so I hope everybody got some great information off of this. And those of you D4 students that are graduating with that associateship, reach out to Class Solutions or reach out to Joe. Start asking these questions and making sure that you guys are prepared. So if you enjoyed our show, please rate us, review us on Apple, Spotify, or wherever you get your broadcasts. I'm your host, Phil Cole, with Chris Webb, the co-host. We want to appreciate and say thank you one more time to Joe Hess, joehesslaw.com. Thanks for listening, and everyone have a great day.
Thanks, guys.